the first to know Nsem-Pii TV.
Okay, abusia for lawyers akasa na womo de Nsem-Pii atodwa afa ayetama Wontumi ni bail condition a womo antimi amiti no eho ama jese empanyufo odi womo anotumbi na womo akire se wasachama Wontumi anka kwan biara so ye mani bail nanso no womo ama ni bail judge na wotena asem no so no womo enim de ntia judge no anhwe ama ya machama Wontumi bail ena afi no saa 15 million cedis na womo na to chama Wontumi etiri so no na ekamya koye se eye okọ embramu a eye po ena gese womo abo se womo machama Wontumi bail fi se chama Wontumi eye nipa bi a odimu ewo oman mu hanum sei oye chairman ena aside that no eye amonyoku a wosa edi djuma ewo mu no amonyoku ni mu no wosanki hwe amonyoku no okọ embra ni mu a osi embra no kan se amonyoku no nko a mu nti no anke betimi amachama Wontumi bail fi se sa sika no sika no so eye sika kese a o de tuni patri so a na kemya koye se washeda ena wo pese wo mfani pa no entum na aloya si kire se wo mu enim ida se judge no oye e dia pe promotion ewo aye na djuma mu enunti anama judge no eye sa na before that no so lawyer Morris Ampaw edin kan ebeka se judge bi obajisika ewo chama Wontumi asemu yo hono wo mo ne no ewo bika na nje se lawyer wi nso asemu aba besiso pepepe nsempanyufo bi na shaase a wo mo atwa sika ena ama wo mo eye chama Wontumi eye saade no abusuafo wo mumyenkunko tie eye lawyer ne nsema oditudwa ena no
ade bia mentimi hu de nti a ebinom sa wohwe court na judges bia fa no binim sesa wo yesa na ya ma promotion a because bail a unconditional release of an accused person and as a suspect be wonim so release sa nipa no a obeba na Supreme Court of Ghana edi Nsem-Pii bra o ma kire o kan Martin Pebu number 2 versus Attorney General number 2 2015 2016 o bon se Supreme Court aka say bail condition any kwan say onerous because giving onerous bail condition bia it amount to what refusal na just say o bail condition na no odia e kire say we refuse nipa no ana unim the purpose of bail a yedemano the most dominant factor I was all consider before and no grant bail the accused person bia no whether or not the accused person will reappear to stand trial. Say accused person beba no abama ya try no enunti na o man bail say ma no be dwane dia and then was say refuse ni bail and ma bail condition no ano ye the nature say ontimi meeti. And Supreme Court also say bail shouldn't be used as punishment. And you can say the bail aya asotwen de ma obi because court no afi no obekọ ensem no akodi asem no na wo hu say nipa no odi for anas because nipa na wache no police for che na oye suspect ana ade ne kogina court a na de ko adubo no afi no oye accused person. So there is a difference between what accused person and a suspect here the police ache no ana accused person say ye de charge abono ne de na kogina court no be accused na bail no court actually said the most dominant factor is section 96(5)(a) of Act 30 ye nyina yisu no ade a was a court no etimi hwe ne kese before ansa no amobi be na institution is whether or not the person will reappear to stand trial say enipa no beba na waba ma ye di na asem ana that is the question I will say ubusa ho na yenhwe hu se da bia mka se enema ben na obetime hu se obeba na oma. First of all, idea was so to me who say any pan beba whether or not say any pan a flight risk. I say ujana ubigane. Whether or not the person is what a flight risk. Whether or not say any pan were men of substance to stand as surety for him. Any pan would no akojina court no. Owo kuku damana say a titri for umbetime jina ho amano. Ama sebe say sankrofo ko jina ho mano e kire se nipa ni dimu for instance so kofa mi kro mu hene ed ni ko gina se onko gina manamu ne ma me bela se na te bia court be grant me e wa chen no and non quan offense one quite immigrant bail man. So the point is, we are well known. Or political party be if said they are binding yeno and now said their court ne yeno and now institution be yeno if it is not actuated by malice and ya adwembone so bad faith and no day ye dia looking at properties in the prominence or memu any political party be or deep party nanim as a what be chairman of that party na so a chairman of that party no region be no and non kwan put me money bail na mpono judge na or this bail condition ne to no so no dey me bisa ne say e dey be mpa na kan what is the gravity of the offense and quantity was as bail condition ya dem out and bail condition you shouldn't look at the offense itself, you look at the most dominant factor ne say whether or not say any panel be appear to stand trial. That is the most dominant factor to be considered. Okay, in the case of Okoy versus the Republic 1976 one Ghana law report, Supreme Court of Sanka Assassin said the most dominant factor was in court to be affair and not institution be affair whether or not the person will appear or reappear to stand trial. Etinipa no beba ababe jina emrane ni mama emrane ne diana. That is the question. If the answer is yes, money bail. Se obedwane nko ade a ene me money bail kopim se ebedi asem ni bewie. The question is chama Wontumi bedwane ana. Chama Wontumi bedwane ana se chama Wontumi mpo bedwane a ede be nipa na edi nanim ana ede be japade na owa so odwane a ebetima fa ede asi anamu eti oye party bi aye political party bi aye opposition aye new patriotic party asa sa party no ankasa mpokura mu ye hwe party no nko aho a e wose ya mane bail enu achi chama Wontumi wa japade bebre enu achi owo men of substance a obi ji said Dr. Mahmoud Bawumia uche sa political party aspirant die ni mu nyina omu bia betima ko stand the assurities e de amano including your chairman of the new patriotic party. Eti die na o judge na wo hwe na ama no onerous bail condition because the ene say wo yesa enche na judge ndo be nwanse ama no promotion.
So we justice Nsem-Pii court to hold no ordinary no be true the entia benka edisobo emani bill de ho kro de ba oh eti justice Nsem-Pii odona na no aye disade no grievous offense be ye
you see
judge no crowd no on shedanti as
you see what are the offense if this charges are they abo Wontumi say charges no one ba ko ye say assignment of mineral right without an approval, assignment of mineral right without approval. Eti almost say Wontumi or license aban na man a license to operate into okuta license no dey na mining and to read the mineral and mining act na amended act no na act na 95 na akere adekora wo ye ho bone a ye de punish wo act na 95 no uhwemu a section 14 any section one of the sections I want to look at it na memfa ubon say section 14 naturally say Wontumi transfer or right na e de amount no say amount or license na Wontumi transfer or right na nsan fa mani pa foforo and they say offense ba ko mo de bo chama Wontumi ne say wa transfer ne right na e de ama no a wo de ye mine ne de ama enkofukuo mienu bi different ye obomudin kra wa ha asa nipa mienu no de akwakoye mine na activity a while need approval from Minister of Lands and Natural Resources. And for that matter, it is an offense and a breach of Section 14 of the Minerals and Mining Act. Enti yachino ese enono omra mebu oma me answer question. 2 wa facilitate amomuju medi a omo ye nanam so de right ne ma oma wa anya approval no wa facilitate abo oma momuju medi na koso ama omo de aye illegal mining ewo ensuomu ne ade no charge we no ma breaking it down wa cooperate omo change words no wa cooperate into omo hwe act ni mu ana omo de facilitating cooperate sa nema na assigning and omo de achiche mu ana omo de abma no 6 count.
It's also basically the same thing.
The same thing omo come around 6 count no the all pede na kwa kwatum ne say e range from say okonsuo no ho na kwaye mining or forest na ene nsuo ya water bodies na eno punish na use excavators any bulldozers need the kokoya offense na no odin because new act no ama 15 years to 25 years.
But already so such chairman so our court or also akọ court dada brother sa dey ma we say nyina
that is so that is my point no eno no masa ba no masa be charge ni biom enti wo hwe act na mining act na section 14(1) ana section 99(2)(b) of the Minerals and Mining Act ehon na say so mo dey charge no assignment of mineral right without approval. So the right na kwa komobi enti ono ade wontimi charge ne say why illegal mining, but what they are doing is we facilitate we assigning the right ne dia common nipa foforo ama say nipa foforo no kra no om do mudin bai enti sa nkrofo no aye bibi sa konta mining no o dia koma okum Henry okum ana Michael Jedu ayisi sa nkrofo no de ne right na koma omo ama omo de aye sa adwumadie no enti sa nkrofo no ade anchi wo mo wontumi no ana yache no pursuant to section 14 and 992 of the Mining and Mineral Act no. It is no ma breaking it down because we are charging now obetimi aluku ahwe offense section no na what west na we use one no breaking it down now they are charging no am an account to be bre say they be ya obenya na asotwe kese de ama no. So the point is court no afi no obehwemu whether or not say wontumi and the right ma wo mana whether or not say baby na omo ye omo miners anipa na eye Henry Okumne Michael Jedu ayisi no om baby na omo ye omo adwuma no na eho eso bensuo ho ana whether or not say omo pollutu water bodies be whether or not say eye wontumi akonta mine no and dey say tumi ni ma wo mana. The court is here to peruse all these things. I feel na court ne ba be hwehwemu.
And so say justice Rems I agent ho do menra o create investigation obo ye nyina na the partner since 2010 or see who the partner no and why nyina. You see press conference or the I didn't get the point.
You see I was say who said the whole state is against one person. I also almost a criminal trial no. The whole state and its accoutrement. Ebiana is against one person. State no ahoɔden nyinaa no de egu nipa baako so. And they will see so we judge you have to balance it. Etinya the state ne beka most often ya na ɛyɛ me ya pii sɛ ɛtɔ da wokɔ judges ne bia ne mu a the state ne ka no ɛsɛ ya no mu tie the state ne ka no more. I won't say a protected state in there, but I was said that balance right, you know, because the 1992 Constitution of the Republic of Ghana, no, I was a yen benefited from the 1992 Constitution. So we all are servants of the laws. We all are servants of the rules, and we need to worship the rules. Et yen na yen kwa wamranenim, and amrana was here summono, and to benefit we uma, and you was a benefit state in kwa, and answer a benefit individual. It is a wujin and tamona your referee, now ye jaja. I was a uma fairness. The point is be conditional. I had the toast I wontumi no so no. E dey nti na ye so harsh, so excessive, so onerous. E dey nti na ye dey sa bail we ato no so. Because sama wontumi ye obi a wo hwehwe na wunya no ana. E dey nti na wo so okoye ne passport, ene ye de copy ni bibia ko all borders, ene ade e dey say dey wontumi nwane. Why are they doing that? When you do that, it amount to persecution, but not prosecution. Because there is a difference between what? Persecution and prosecution. Because all person persecute now. There's a wapa na say nipa we do when you see no. But state no talk about prosecution. Also prosecute no. E two prosecution na for charge ne bono. We are judge nso a men hwe enka say in fact abanti say the nipa na begina wa e wo say me man be condition ano den say the betimi a ontimi meeting no dem. So at the end of the day nipa ne dem no wu amfa so be na abenya. Because we shouldn't forget the fact that say Chama Wontumi is a citizen of Ghana. Notwithstanding, regardless of ABA, why ya men fan say bia, it's here or my anabi be a tessa or a citizen of Ghana. The fundamental human right, so of essence, I hear. So the point is that we are the Chama Wontumi them no the contribution towards this country no ebasa na wagwa because anye bia no Chama Wontumi be woni pa bi wo ha wo hwe wo mo. Anye bia no Chama Wontumi wo nyuma bia enipa bi ye bi am ye tue omoka. So the essence ne say o detain na mana sofa e wo jail ana say o detain na mana sofa e wo cells na ana police custody na che say why mere ana so wa famu de ewu ana. That is what your judge ade e wo say wo think about. Not necessarily. Esa obeka obeye wadwene say me mano bail conditioner is so onerous because the onerous bail condition no it amount to a refusal. Supreme Court aka. In the case of Martin Pebu, so man onerous bail conditioner it amount to refusal. That means that o person will refuse no. On person be man bail dada. Anything one man onerous bail condition so that ultimately meet sa onerous bail condition no na yasan detaining and na yede call police custody. What is the essence of it? When Supreme Court has already spoken against this a Supreme Court authorities a Supreme Court nyina no e kire say bail bia ni kwa shouldn't be used as punishment. Eti di na o ma nipa no punishment na odi netum na akoma say sika kakraka wi na property a okofa ba nyina no just e ko value ansa hunu ne bo say eni sika na odi ato no so no e nyina ye pa ba $1.5 million ansa na watimi anya bail di akọ o ma be ne ye chekere ne sa no
Mate, lawyer, but that's it. Besa aba unche ebi.
Na be topical issue na sa asem na o say ya kan na ejaka. See President Akweshia CSUs. Na follow from the meeting na say they are not showing any commitment. Anko for start take kan ho asem. So e dey na o say ye. I was say ya kwachi obi. Na ebe he na sansem ni nyina yija kan ye kan we na apart from that no keke me minim enye NDC fo ya ka minim say charge obi or criminal lawyer na wa me menye lawyer by MPP time me anti say ya CID for ebe fa ko those who were charged for causing financial loss ness anima we be hu ayina na charge sheet from court yes omo enya omo nyina wie ni we say me call lunch about 1 o'clock into me kodidi omo frustrate we omo sa na mitie ye na asemba ko a me dem nye lawyer but dem tie say o say omo so omo ko hu abrantio omukohu abrantie bi ewo Samra boy concession na edi ama no legally no omukohu abrantie bi wo mu a oye adwuma ho omubisa no o say akonta mining for na say omra meye adwuma nti nipa ba ko oti o to muhu abrantie bi wo ho na omubisa abrantie ne say wo ye de wa ha no abrantie ne say eye akonta mining na afa ne say o meye adwuma wo ho intene say akonta mining na afa o say be ye adwuma wo ho de a ene na kire say ya transfer e di amount inti afa na asem no wuko prove say o say evidence bem say keke ma transfer the amount they say document ye be kwa agreement ni ade intino say na former National Bureau for the NEC ya omukohu because of national security ni omentino omu in leave trace for financial transfer ni ade inti omu be dummy account ne sa names ni ade ni nyina omu de ko eweko ko hunu name bia am say any personal account no okoye press conference ko che ne yere ko che abra say akosi say I say okay say national service case by the same thing ebesi sabri wati ho asem bio to the extent say sisi ameno ka say enkwara ewie university tertiary schools was say omo register for national service October was say come start national service
yes you am register
NDC for buy national service platform no ma close in this enkwara ntimi register no my national service what I say na keke ade ba akoma menka we keke eno krani say 15 million Ghana cedis me maame a ote abo oka 15 million na onim say 1500 Ghana 150 billion
yes
it is can 150 billion
ebi omo akra say scam it
150 billion
and you baako
the second one 10 million Ghana citizens and also 100 billion and Tuesday now call police CID for honomo almost man the bail of 1 million which is Titisicano 10 billion so
nipa baako
na ade a ehu ade m se Ghana ha keke se u si dan no one farm ma contractor ono no be ma official receipt be hunu o dan ne value now the adwuma no koma ye normal artisans mason fuo ya o charge o na we tua ne ka sometimes ebu a nsuo kra se wontu nsuo o fie na even se wontu nsuo o fie a se nsuo no e value enti nsuo nko a wo de ye adwuma no be den na the value atoso
aso value aso value
se ukoto nsuo water tank for no ho ena de bro na di twa blocks keke ana se wo de eye adwuma a o se ni nyina ye value te wan koto nua ena woko wa ukrom kotwa nua ena ade abeba wo dan so ha ni nyina value Ghana ha nipa dodo se na esi dan de ma contractors just landed property ye be den ya value Wontumi tracking receipt ni bebre ntimi na mede medan me sika se na me boy value abeba begina ho no aka amount bia ono aka cho say dan we ni value nuru dia wo kan nti nipa ne de koye surety enyeyi
and the state na so na de na ba
yes mo ma yen hwe de ekoso no cause ochina bi ebetimi ayewo wa uti
mi serious ono aba na ono value ne de
asem no wo de fa ye de na ekokoto ama court akodi na asem nti wo be kwa use evidence e court na court no away the weight of your evidence any ebehwe. But look at this, one court to say 100 billion sene be ya me ma me beti ase another court to say 150 billion o kan iboma 250 billion bail condition property o ya am say enye sika equivalent to landed property
and the value
eduru sa and this our for bedroom bi masa ontumi mfa nko ho nkoka se ena ba bi kra wasi dan no asase ne bo area wasi dan no kra kire edigeke utranye na se echiwo na wuni obi a ebi a wasi dan ewo East Legon ajire gano mu eni twasako anasa obe kumasi a hilltop mu ni ade a ho dwomu ne de nyame mu a ehon prime area nti asase ne bo kra no ebetimi akosora keke ubedemu a yama obe nso wunya ubedemu a mo ahwe ya ubewu ho president almost set no no ba se obi ayedin ewo man nim